Good evening everyone, and welcome to Melbourne Law School for this third event in the Conversations About the Voice series. I'm Jason Varuhas, a professor here in the Law School and Director of the Law School's Centre for Comparative Constitutional Studies. I'd like first to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which we meet, and pay respect to elders past and present, and extend that respect to Indigenous Australians present here today, and particularly Taryn Lee, who is one of our panellists this evening, and Tim Goodwin, who is joining us online and who is a co-convener of the Conversations About the Voice series. The event this evening is the third event in the Conversations series. The series is organised by the Centre for Comparative Constitutional Studies at Melbourne Law School, and is designed to bring expert analysis to bear on core issues relating to the voice proposal and referendum process so as to inform public debate and understanding in the lead up to the referendum later this year. The series seeks to provide an interactive forum where members of the audience can participate in the discourse and have their questions answered. The series is convened by Tim Goodwin of the Victoria Bar, Professor Cheryl Saunders of Melbourne Law School, and myself. So this evening's event is entitled The Voice, the Courts, and the Rule of Law. Previous events in the series have addressed the interrelationship between the voice and the political branches of government, namely the executive and parliament. This evening our attention turns to the potential interrelationship between the voice and the courts should the voice proposal be passed, an issue that is featured prominently in public debate. Our panel will consider the potential role of the courts and litigation in relation to the voice and seek to place the court's role in the broader constitutional, legal, and political context. Let me now introduce our fantastic panel. Cheryl Saunders AO is Laureate Professor Emeritus at Melbourne Law School and Foundation Director of the Centre for Comparative Constitutional Studies. She is one of the leading scholars in constitutional law in Australia and in the common law world. She's made many contributions to public life, including recently serving as a member of the government's constitutional expert group on the voice and as a member of the government's expert group on reform of the Federal Administrative Appeals Tribunal. Elizabeth Bennett SC is a barrister at the Victoria Bar with a broad practice in administrative and commercial law. She's been a barrister for over 13 years and was appointed senior counsel in 2021. In addition to advising government in a range of areas, Liz has appeared in a number of matters involving novel questions of law, including in the High Court, and she has been counsel in matters connected with the Native Title Act and the Traditional Owner Settlement Act. Taryn Lee is a Yawuru woman originally from Broome in Western Australia. She is currently General Manager for Social Impact and Policy at Collingwood Football Club, where she is working on organisational change to address racism. She's also currently Chair of the Board at the Victoria Equal Opportunity and Human Rights Commission and Board Director of Parks Victoria. Previously, she has held senior executive roles at PwC and the Victorian Government and has been responsible for designing and delivering policy reform in health, justice, and Aboriginal affairs. She has also published scholarly work in the field of Indigenous rights. So in terms of the running order, Cheryl will speak first, followed by Liz, Taryn, and myself. We will each speak for 10 to 15 minutes, and then there will be time for audience questions, which Cheryl will chair, and our colleague Jayani Nadarajalingam, who is a lecturer in the law school, will moderate the online questions. Lastly, I note that this event is being recorded. So we'll now move to the formal presentations, and I'll invite Cheryl to start.
Thanks very much, Jason, and good evening, everyone. I also acknowledge that this seminar is being held on the traditional lands of the Wurundjeri people of the Kulin Nation. I pay my respects to their elders past and present, and to other Indigenous people who are with us tonight in the room or online, including Taryn and our colleague Tim. So as Jason has said, the focus of tonight's event is the role of courts in relation to the voice as it would be established under the new Section 129 of the Constitution. And as he also mentioned, this seminar follows an earlier one about relations between the voice and government and parliament. And that order is deliberate. The concept of the voice is designed to ensure that it operates primarily within the political sphere, providing a measure of self-determination for First Nations peoples through interaction with the elected branches of government. So it seemed logical to us to begin by asking what this interaction would look like and how the opportunities that it offered could be used to best effect. On the other hand, the draft amendment also leaves some role for the courts, consistently with Australia's commitment to the rule of law. So the purpose of tonight's conversation is to explore what role the courts might or could play and to assess its significance. So I'm going to begin by covering the basics, sketching some of the possible openings for litigation and some of the key issues canvassed in the debate so far, and then I'll hand you over to more interesting people. Now, we can get some impression of the extent and limit of the potential role for courts by just looking at the proposed new section. Those opening words secure recognition and provide nothing for courts to do at all. Subsection 1 requires that there be a body called the voice. No court would force the Parliament to set the voice up. Once set up, a court might issue an order to prevent the legislation being repealed so as to abolish the voice altogether, although even that is by no means certain. Subsection 2 sets out what the voice can do. As you can see, it provides that the voice may make representations to the executive government and the Parliament on matters relating to Aboriginal and Torres Strait Islander peoples. If the voice were to exceed any of those limitations, and if a case of some kind could be mounted, a court could issue an order to keep it within bounds. But it's not obvious that such a case would get off the ground in procedural terms, and it's also not obvious why anyone would bother, given that the function of the voice is limited to making representations. And then subsection 3 provides a broad but not unlimited power for the Parliament to enact legislation with respect to matters relating to the voice. That's the power the Parliament would use to set the voice up if the referendum were to pass. If Parliament were to exceed that power under subsection 3, a legal challenge might be made. And similarly, once a valid law is passed, both the voice and the executive will need to comply with the law, as with any other law. Now, there's been a lot of discussion about the role of courts in relation to the voice over the past 6 months, but none of it deals with any of these possibilities. Rather, almost all the discussion has focused around a different set of issues, raising concerns that the power of the voice to make representations, that power in subsection 2, might be held by a court to impose implied obligations on the government, and in doing so, to overburden the processes of government. Various forms of this concern were explored in the recent report of the Parliamentary Joint Committee, and I'm going to use that report as a convenient lens into the points that have been made. So first, let me put the report itself in context. When the Constitution Alteration Bill was introduced into the Parliament earlier this year, it was almost immediately sent to a parliamentary committee to report on any constitutional or legal issues that it raised. That committee comprised 13 members from both houses of the Parliament across the spectrum of parliamentary parties. It received 270 submissions and more than 3,000 other contributions, songs, etc. And it held 5 public hearings at which 70 witnesses appeared. In conclusion, The committee's report accepted that the wording of the proposed change was, and I quote, constitutionally sound. It's a term that I find very weird, but you get the general message. And that the bill should be passed unamended. And it described this conclusion as consistent with what it describes as the consensus of constitutional experts, although it acknowledged that some experts took a different view. There were 2 dissenting reports by the Liberal and National Party members of the committee respectively, and the first of those deals with the legal arguments at length, and so it's most useful for present purposes, for our present purpose of exploring what these arguments are. At its highest, the concern expressed in this dissenting report was that the court might imply, from that power of the voice to make representations in subsection 2, duties for the executive branch to do one of 2 things. First of all, the concern was that the executive might be constitutionally required to give notice to the voice whenever it proposed to act in a way that affected Aboriginal and Torres Strait Islander peoples. And the second concern was that it might require the executive, as a matter of constitutional law, to consider any representations made to it. And so the argument went, if either implication were drawn, failure to comply with it would make an executive decision invalid, requiring the decision to be made again. It was suggested that these implications might be made because otherwise representations would be pointless. What's the point in making representations if a court can't force you to comply with them? And it was also said that either or both of those implications, if it were made, would unacceptably disrupt the business of government. So that's the guts of the argument. I've simplified it a bit, of course, but I hope you can follow it. No clear solution to these possibilities was offered in the dissenting report, but various options were suggested in various forms. And I'm going to mention the 2 of the most prominent, which have also been canvassed in the press and so on. One proposal is you remove those words executive government from subsection 2, so it's only a power to make representations to the Parliament. And the second proposed suggestion is to remove section 2 altogether, leaving the functions of the voice entirely to the Parliament under subsection 3, but with some protection from the general constitutional protection, freedom of political communication. Now, both of those solutions or options are highly problematic. The first of them, removing executive government, would inhibit the voice from engaging with the one branch of government by whom the real decisions are actually made. And the latter, removing subsection 2 altogether, would leave the voice as a hollow shell, to be filled up by Parliament in whatever way Parliament chose, in ways that could go well beyond a power to make representations. Now, this rather technical debate over the role of courts under the proposed section 129 has the potential to confuse voters in the approach to the referendum, causing people to vote no almost by default because they can't really understand what's going on in the debate. And to make matters worse, this particular argument is almost inevitably inconclusive. However far-fetched a claim might be, and might be agreed by all sides as being pretty unlikely, it's always difficult in such a context to deal with the riposte, but can you guarantee this will never happen? Well, never is a very long time. And if you give such a guarantee, you risk looking very rash or probably a bit stupid. Nevertheless, I'm prepared to say that this is about as close to guaranteeable as you get. It is correct that the High Court sometimes draws implications from the Constitution when it considers that these are necessitated by the text and structure of the Constitution. We can all also readily agree that we need to do whatever we can to avoid Australian government becoming completely unworkable. Nevertheless, speaking as a constitutional lawyer, I think there is no chance the High Court would draw these particular implications at all, and certainly with the consequences claimed. And let me give you my reasons for that, and you can evaluate them for yourselves. The first is this. The Australian approach to constitutional interpretation is cautious and incremental. The High Court never takes a great leap into the unknown. At best, it works towards the unknown in gradual steps. And in interpreting the Constitution, the High Court prioritises text and structure. And by structure, I mean the way in which words are put together in subsections and sections and chapters of the Constitution. The text and structure of Section 129, or proposed Section 129, militates strongly against these particular implications. It does so most obviously in the choice of the word representations. Representation, I don't know how you think about it, but it's very much a one-way street. I make a representation to you, you may or may not acknowledge the representation. But the section also, I think, militates against these implications by coupling with the executive with the Parliament. It'd be odd for the court to say, well, the Parliament isn't subject to these implications, but the executive is. It tends not to be the way the High Court works either. Another feature of the section is also the breadth of that reference to matters relating to Aboriginal and Torres Strait Islander people. Sometimes it will be obvious that the executive is doing something in relation to Aboriginal and Torres Strait Islander people, so perhaps it could give notice. But sometimes it won't be obvious. It will be a step taken in relation to us all that happens to have a particular distinctive effect on Aboriginal and Torres Strait Islander people. And the court will not expect executive government to have a crystal ball. Second reason, the meaning that I've just suggested to you is attributable to the text and structure of this section is further reinforced by everything that's been said by government ministers and in Parliament about what the intended meaning of this provision is. And the court will look at those sorts of materials if it's in doubt about what a new section means. Third reason, the possibility that an implication might cause significant disruption to government, much less make it unworkable, is yet another reason why such implications would not be drawn. And finally, and I'd like you to think about this, it's not correct that the power to make representations would be meaningless unless the government had constitutionally implied enforceable duties through the court system. On the contrary, like much of the rest of the Constitution, the voice is designed to rely primarily on the political process rather than on courts for its effect. Now, I've given quite a lot of thought to all of this, and that's where I've landed on this question of implications. But I'm happy for you to think about that, and hopefully we can pick up some of those points in question time. And now let me turn you over to my colleagues for other perspectives on tonight's theme, beginning with Liz.
So I'd like to just start by noting that while I'm a member of the Victorian Bar and I bring that perspective, these opinions are only my own, and I don't speak for anyone but myself here tonight. What I'd like to do tonight is address quite squarely the ways in which it is said the voice could be a threat to the good working of at least 2 out of 3 of our arms of government, that being the courts and the executive. Because these have been really the primarily deployed propositions recently about why we should reject the constitutional amendment that's being put to the people later this year. So I decided tonight, perhaps a little bit David Attenborough style, we might just observe a hypothetical barrister who is briefed to try to disrupt the courts, to try to disrupt executive decision making. And we're going to see what that lawyer, who I was going to call Lawyer X, but then I decided Lawyer Y was less taken. And we're going to see how Lawyer Y navigates this situation. Let's not worry about Lawyer Y's motivations. Let's just see how they go. So first of all, we're going to see how Lawyer Y is going to try to slow down and disrupt administrative decision making. So that is decisions that are empowered by law. Administrative decision makers have a statute that says you're allowed to make this decision. You can decide this is an off-lead park for dogs. That's an administrative decision. They are allowed to make decisions like that because they can point to a statute that says that they can do it. Decisions like this are made every day. And they are challenged quite a lot as well. So Lawyer Y is going to try and challenge decisions based on the voice. So we're looking for a reason that Lawyer Y can challenge because the voice exists where they had no such avenue before. Now, the first problem that Lawyer Y has got is that you can't just challenge laws because you don't like them. You need to have some standing. You've got to be different from everyone else who's subject to that law. So it's not open to an interested citizen just to challenge a decision they don't like, or even because they're kind of, on a principled basis opposed to it. Cases can only be brought by people with standing to bring that case. And the High Court's position about that is very clear. And while I'm not going to read much from judgments, I will say that they do say, the High Court has said, a belief, however strongly felt, that the law generally or a particular law should be observed or that conduct of a particular kind should be prevented does not suffice to give its possessor locus standi, which is a very, very pretentious way of saying doesn't give you the right to challenge it. So the first thing Lawyer Y needs to do is find a client who has a special interest in that dog park for some reason. Self-evidently, it's not okay to just intervene because you're interested or you think a decision was wrong or you think that anything else for that matter. But let's assume in Lawyer Y's favour that they found somebody with standing. We're hoping for that person's sake they have pretty deep pockets because the next thing they've got to find is somebody who's willing to bear the cost risk of pretty significant litigation. Now, Ben Roberts-Smith is a pretty extreme example, but anyone who runs a case in our courts does face some pretty substantial risks if they are unsuccessful, and the presumption is that they will pay the costs of the other side, and those costs are not small. As I said, Ben Roberts-Smith might be an extreme example, but certainly these are not trivial amounts of money and not to be done lightly. Nonetheless, let us make the increasingly unlikely assumption that Lawyer Y has found a client with standing and is willing to risk their house to challenge a particular administrative decision. And let's go and look at the substance of how they might try to do it because of the voice. So Lawyer Y is probably going to be tempted to argue, or at least this is the argument put in Lawyer Y's mouth by, I think it might be said, opponents of the voice, that a decision has been made that is not consistent with a representation made by the voice. And that, at its core, is an attack on the merits of a decision. I don't like the decision that you've made. And that, again, is self-evidently what the law of administrative review doesn't, or judicial review doesn't allow us to do. You can check to see that a decision is made lawfully, but you don't get to check that it's even correct, or what you think is correct. That is a matter that is simply not open on this challenge to the courts. We check that it's within the power conferred by the statute, not more broadly. So Lawyer Y, by this stage, has now got to fall back to some creative lawyering. And the traditional way of trying to run a merits review without running a merits review is to argue that you should have taken into account what we call a relevant consideration. Now, here's the catch. A relevant consideration can be taken into account. It can even be ignored. The only thing that is going to affect the validity of the decision is if it's a mandatory relevant consideration. So you've got to be compelled to take it into account. And that begs the question, what does the compelling? What makes something a mandatory relevant consideration as opposed to something you can think about if you want to, or a decision maker can think about? And the answer to that is the statute, the empowering statute. The thing that says you can decide what's an off-lead park and what's not. That's where you look to find out, generally speaking, what are the mandatory relevant considerations. So if that statute says you must take into account what is said by the voice, you might well have a mandatory relevant consideration. But that's in the gift of Parliament. That's not a constitutional amendment. There's nothing in the constitutional amendment that Cheryl showed us before that would make anything a mandatory relevant consideration. It's quite different. A representation is quite different to a mandatory relevant consideration that would imply itself into every decision of an administrative decision maker. So we would be at best there would be an argument that a representation made by a voice is a relevant consideration, and I have some sympathy for that view. A decision maker probably could think about a representation made by the voice and not fall into error. But would they be required to think about it is the key question, and I can't see any basis to suggest that it would be required to take that into account unless Parliament passed a law, any Parliament passed a law saying you can't make a valid decision about this unless you have taken into account what the voice says. And that, of course, is precisely a standard form of practice that you could, because Parliament can give or take that as they see fit. So there's nothing unusual or concerning about that from a constitutional perspective. So Lawyer Y is now struggling because there's just nothing in the text of the Constitution to put it into the category of mandatory considerations that must be taken into account. And those are classically matters for Parliament to identify. So even if Parliament did, and I just want to emphasise this as well, even if Parliament did decide some categories of decision had the representations of the voice as a mandatory relevant consideration, even that is not as big a deal as one might think. It's quite a common thing for there to be lists of mandatory relevant considerations in acts. But even if Parliament did designate representations in very specific areas in that category, the best argument Lawyer Y would have would be that in certain contexts that representation would need to be considered, not complied with, not given an elevated status, just considered. And it really is only the legislation at issue there which tells us when and how that should happen. So if there were no legislation, I don't see a pathway for Lawyer Y here. So in the best case scenario, if there were legislation added to the enabling enactment, the best Lawyer Y could say is you really should have thought about this. And they'll be able to deploy that if they can find a client with standing, with funds, and the enabling legislation says so. Lawyer Y will then need to show that the decision that was made was that the failure to consider the voice's representation as required by the statute was material. And if they can't show that, then they will again fail. And if passing all these hurdles, in all of those order, at the end of that time, the best you would really get is a remittal back for the decision to be made again. And anyone who's ever been through this process can tell you that's not much. Now, I'm not by this trying to undermine what's important about the voice, but I think it is important to understand that the fear-mongering about this being something that is going to clog and delay administrative decision-making really is unmoored from the experience of the practice of the law as well as the black letter of the law. The kinds of arguments that I've just identified are all fairly routine and well rehearsed, and courts are well equipped at dealing with them. And this is all fortified by the subsection 3 in the amendment that Cheryl just showed you, which tells you that Parliament is intended, and by the text of the constitutional amendment would have, the power to make the laws that demonstrate and identify the way in which the voice would function in particular circumstances. Now, of course, there's vexatious litigation. The voice is not the cause of vexatious litigation. And what I mean by that is spurious claims, people issuing writs that have no prospect of success. The voice is not the cause of that, and I have not yet identified any amendment known to the law that can prevent vexatious claims from starting. The fears of lawyers' picnics have been deployed against a range of reforms, and I think it's good to pause and, if in your spare time, try and Google lawyers' picnics or fears of a lawyer's picnic, and you'll find a vast array of things that have been said to be a concern on that basis. I this afternoon found section 44 of the Constitution, which was pretty picnicky for a while, the Human Rights Charters now, new patent legislation, which I do not understand, and electric cars, bafflingly. I did not have time to work out why they were said to give rise to a lawyer's... Oh, I see, Vanderstock, got it. All of these matters are said to give rise to lawyers' picnics, and really they haven't resulted in a grinding to a halt of our system. And the reason that these lawyers' picnics are never as destructive as people predict is related to the next topic that I think will challenge our intrepid Lawyer Y, and that is as Lawyer Y attempts to undermine the functionality of the High Court because this is one I've heard a lot in recent months as well, that as well as administrative decision making, the courts is going to get clogged up. And I think I've sought to demonstrate is that with lawyer-wise best endeavours, there really is no rational basis upon which that fear is bounded. The other argument that I've heard deployed is that the High Court will itself be inundated, ground to a halt, unable to function. And it is not entirely clear to me where this flood of litigation to the High Court will come from. Attempts at judicial review really aren't managed entirely at the Commonwealth level. There's where they concern officers of the Commonwealth, you can go to the High Court, but they have a remittal power and it is used freely. In fact, I think it's fair to say the High Court is one of the best managers of its own business of any court in the common law world. And as Cheryl's identified, Section 129 doesn't create any legally enforceable rights or duties. It's facilitative. It perhaps requires the existence of a voice, but I mean, you can't take Parliament to court to require them to pass a law, so that's not really going to get you very far. And as Cheryl's pointed out, the text of the constitutional amendment is also clear. It's a body that can make representations and left representations alone. And so we're left with this notion that by implication there will be something that does something to the High Court. And Cheryl's talked a little bit about implications, but I think there are two that stand out for me as being the ones that people have in mind when they're talking about, something bad might happen, capital S, capital B, There are two that arise to me. There's the implications in the Constitution, like the implied freedom of political communication, and there's Mabo itself. So there's the notion that we didn't know that the implied freedom of political communication was there. It was implied, therefore it's radical, therefore it's unforeseen, therefore it's to be feared. It's a precedent for the notion that an unintended consequence might happen. And similarly, Mabo is an example of the common law coming to recognise that the base upon which the land was stolen in Australia was misunderstood by the common law or inappropriately. It's hard to find the right words, but it was based on a myth until the High Court corrected that in 1992. But it's worth noting that in both of those instances, the High Court was at pains to make clear that anything that undermines a core tenet of our constitutional system is utterly unacceptable to it. And so the notion that we should fear such an implication arising in an unintended manner is, in my respectful submission, mischievous. So even the High Court has recognised that it is appropriate. The implication of an implied freedom of political communication is implied because it is necessary to give voice to our system of representative and responsible government. Not because it would be inconsistent with it, but because we need it to have that form of government. That's where the implication comes from. And similarly, in Mabo, when the court dismantled terra nullius, it said that in doing so, and I'll quote again, in discharging its duty to declare the common law of Australia, this court is not free to adopt rules that accord with the contemporary notions of justice and human rights if their adoption would fracture the skeleton of principle which gives the body of our law its shape and internal consistency. Now, this is from what most people consider to be the most activist High Court in our history, and it pauses in the midst of one of what many consider to be its most significant decisions to say, we're not free to do things if it would harm the fundamental shape and function of our legal system. And it's really important to bear that in mind when you're considering the notion of the probability or possibility of attacks that undermine those very central tenets. And that's really the core of the attacks made against the voice. So the notion that the voice would somehow permit an interpretation, let alone require an interpretation of our constitutional setup that allows it to be hobbled or overcome or clogged up really doesn't hold any water. So really what is left for lawyer Y is the notion that we cannot be sure what a future activist High Court would do. And to an extent that is true in the sense that I cannot guarantee that the sun will rise tomorrow, nor can I guarantee that an activist High Court 100 years from now doesn't take a view that we can't now predict. But we can be guided by 120 years of High Court jurisprudence, which speaks with one voice about the need for the form of our representative and responsible democracy to be preserved. And so any argument that is made that attacks at that fundamental tenet ought to be rejected, and we should respond to this proposed amendment to our Constitution on the basis of what it is and not on the basis of unknown and unknowable fears. And they're only unknowable because, as I hope I've tried to demonstrate through the adventures of Lawyer Y, they fail at almost every hurdle to create the kind of chaos that people suggest they might create. So look forward to discussing when we have some question time.
As is our custom as First Nations people, and as a proud Yarra woman from Broome, I would like to acknowledge the traditional owners of the land, the Wurundjeri people, and pay my respects to their elders, past and present, and to other Aboriginal members of our community. I want to acknowledge that sovereignty was never ceded and that this is and was and always will be Aboriginal land. Thank you for inviting me here today. I feel a little bit out of place. I'm not here to give you a legal perspective or provide football commentary. You're welcome. And I speak with you in my personal capacity. Today, I would like to share with you some of my observations about the role of courts and my aspirations for the voice. In doing so, I want to convey my fundamental belief in Aboriginal self-determination. Since colonisation or invasion, First Nations people have sought to have our truths heard through the courts. We have sought justice for the historical and contemporary wrongs of the colonial project. However, the courts have been a place of injustice for many First Nation peoples. The courts apply laws that are unjust in an unjust system that have not taken into account First Nations perspectives. Today in New South Wales, First Nations people make up 30% of the adult prison population, and 57% of children in prison are First Nation, yet present 2% of the population. The courts have generally applied laws in the absence of First Nation people's expertise and experience, or in a way that has given primacy to non-First Nation people's voices. There have been many cases where anthropological expertise is preferred over the cultural knowledge and rights of traditional owners, resulting in unjust outcomes for First Nations peoples. The perfect example is the Hindmarsh Island case. Even the perceived successes of the courts are not necessarily regarded as just by First Nations people. Lawyers love Mabo because through that case they afforded some rights to Australia's First Nations people by overturning their own fiction of terra nullius. In that story, lawyers were the agents of change and played a key role in determining an outcome for First Nations people. We didn't need the courts or lawyers to tell us that terra nullius was wrong. Eddie Mabo fought in the courts for our continued rights and recognition, like many before him and those who continue. However, the rights given by native title have in many cases distracted us from our own nation-building laws and customs, and many still struggle to determine the potential of native title on our own terms. The key imperative of the voice is to ensure that change is determined by the expertise and experience of First Nations people within the systems that impact us. There is a necessary ambiguity about what the voice will entail in a practical sense. Its success will turn on the form it takes in legislation over time, and this will depend upon the extent to which Australian people hold government to account in ensuring that the voice represents the genuine and complex concerns of First Nations people, and that is that Parliament that is, Parliament to act in good faith. And finally, its success will depend upon the extent to which the other aspects of the Uluru Statement, truth-telling and treaty, are implemented in a meaningful way. The voice, in the absence of the other pillars of the Uluru Statement, will look very different to a voice that sits alongside truth-telling and treaties. In my view, it will be a lost opportunity for genuine and meaningful change. But I do want to talk about hope and the potential impact of the voice on the courts. A successful referendum and the voice may allow for the courts to administer more just laws. If the voice gives greater weight to First Nation voices in the laws that are made about us, then we can expect better outcomes. I think a great example is Victoria's treaty legislation. Those laws could involve redefining court processes through legislation to reimagine dispute resolution, to involve truth-telling and healing, to create a mandate for courts to interrogate how they use their existing rules so that their processes are more just for First Nations people, for courts to use their existing powers to move the voices of our voices from the margins of the legal process and place them in the centre. For example, when considering cultural rights in a case, to place our cultural knowledge as the most reliable authority, as experts, for our knowledge and rights to be privileged. It is important to reflect on the moral and cultural impact referendums take on and their capacity for change that is distinct from their precise legal meaning. 1967 challenged segregation and gave equal citizenship in the popular imagination of the nation. Whether this was actualised is a discussion for another day. This referendum can drive the collective idea that First Nation peoples have a unique identity and a voice within the system to create a space for Aboriginal self-determination. The voice and the Makarrata process invite all Australians, including the legal profession and the courts, on a journey that will be iterative. In that way, the effect of the voice on the courts is something that will necessarily develop over time. The legal system craves finality. However, we have to put faith in a process that the voice and the Uluru Statement will allow First Nations people to express and strengthen our own voices in all aspects of Australian society, including the justice system. Our voices have always been here, but we need opportunities to be self-determined and to build our nations without the distraction of trying to establish our right to exist. As Toni Morrison says, the very serious function of racism is distraction. It keeps you from doing your work. It keeps you explaining over and over again your reason for being. Importantly, the voice must encourage non-Aboriginal people to learn, to listen, to work together, to find solutions, and to give up power where necessary. And to give First Nations people the opportunity to find our voice and strengthen our nations in the absence of racism. Many First Nations people have expressed scepticism about whether the voice can achieve these things, and rightfully so. We have been burnt by false promises, with Hawke's Treaty Promise, native title, discrimination laws, to name a few. But from my perspective, if our better selves emerge through the voice, truth-telling and treaty, then my hope is that the courts will not continue to administer unjust laws in an unjust system with unjust outcomes in a manner that silences and disempower First Nation voices. If our worst selves emerge, this country will continue to not listen to us. This is no small thing, no simple bureaucratic change. It is a huge step for all of us as a nation. To be heard, listened to, this step will need everyone in this room and your friends, your families, and your communities to deliver the yes vote. On behalf of my Yawuru ancestors and on behalf of the next generation of First Nations people from all over this country, I ask you to walk with us in changing this country's constitution to recognise its First Peoples, to hear us. Gala Mabu.
So, as I mentioned in my opening remarks, a core focus of the public debate over the voice so far has been on the potential role of the courts and on the prospects of litigation, as we've heard. Now, in my brief remarks, I want to suggest that the preoccupation with the courts is a red herring. Under the voice model, courts would play a minor role. The major and intended impact of the voice lies overwhelmingly in the domain of democratic politics and policy creation, not in the domain of law and courts. And as such, it's the ramifications of the voice for our political system that ought to be at the heart of our discussions. So the place I want to start is with some broader themes in constitutional and democratic politics, and in particular, the persistent problems posed for minority groups by the majoritarian nature of democratic systems. So a common feature of democratic systems is that they're premised on a principle of majority decision-making. MPs are elected to office because they win a majority in their electorate. A government is formed because it has the support of a majority of MPs in Parliament. Laws are passed if supported by a majority of legislators. So majoritarianism is hardwired into democratic systems. And we know, as a matter of ordinary political reality, that political parties aren't seeking to convince everyone in society to vote for them. Rather, they concentrate on convincing a majority of the populace to vote for them, that is, a proportion sufficient for them to form a government. Now, democracy obviously has much to commend it. We know of no better alternative political system. But one of the well-documented and persistent problems with democratic systems is that because the majority rules, minorities, particularly small entrenched minorities, can face a difficult time. So in particular, they can face two difficulties or risks. First, there's the risk of voicelessness. Minority groups may suffer disenfranchisement or marginalisation within legislative or policy processes because MPs and governments may principally be focused on hearing from and satisfying the wishes of the majority on whom their electoral fate ultimately depends, and or satisfying various powerful organised interests that make for valuable political allies. Now, second, there's the linked risk that laws and policies are tailored solely to the needs and interests of the majority and or vested interests. The corollary is that minority interests may be neglected. Laws and policies may not be responsive to or tailored to the needs of minorities, or at worst, the interests of majorities may be pressed so strongly that laws and policies operate to oppress minority groups. Now, in Australia, Aboriginal and Torres Strait Islander peoples, the first peoples of Australia, have encountered these difficulties, as we've just heard. The position of First Peoples is further exacerbated by the fact that they're a very small percentage of the population by percentage and have suffered serious deprivations through colonisation and its after effects. So Indigenous peoples have faced barriers to political participation, to having their voice heard within the corridors of political power. And in part, as a result, policies affecting Indigenous people have not been effective, and there have been some policies or practices that are oppressive. So the question is, how does one address these twin concerns of political voicelessness and unresponsive laws and policies to the experiences and concerns of Indigenous people? So one possible response that's often suggested is a supreme Bill of Rights to afford legal protection to minority interests, and which allows courts to strike down laws which violate enumerated rights. Now, it's that type of institutional model that would give courts a central role and may be likely to lead to expanded litigation. And that's because the Bill of Rights model is one that very much depends on court enforcement and court-based adjudication. Ultimately, however, that model suffers drawbacks, including that it involves courts determining the content of minority rights rather than minority groups charting their own course. And its biggest drawback is that it would remove social and policy matters from Parliament and place those matters in the hands of judges. And one only needs to look at the various controversies that have attended the United States Supreme Court to see why one might be skeptical of giving courts that sort of role in a constitutional system. So in turn, that brings us to the voice model that will be put to the Australian people later this year. The proposal is to recognise Aboriginal and Torres Strait Islander peoples as the first peoples of this country by creating an independent body that would be comprised of representatives of Aboriginal and Torres Strait Islander communities, and which would have the power to put Indigenous views to the government and to Parliament. Now, the voice proposal can be rationalised as a response to the twin issues faced by Indigenous people of voicelessness and unresponsive laws and policies. So unlike the Bill of Rights model, the voice model is one designed to operate principally in the political sphere. It would clear channels for political participation for Indigenous people. It clears a path for Indigenous people to have a say in laws and policies that affect them. And in this way, it seeks to resolve the issue of voicelessness by hardwiring an Indigenous voice into the political system. And the model also seeks to resolve the problem of unresponsive policies and laws by enabling Indigenous people to relay their experiences, hopes, aims and concerns to policymakers and lawmakers with the goal of facilitating the promulgation of laws and policies that are responsive to Indigenous interests and are effective. So as I've said, the voice model is designed to principally operate in the political sphere. The corollary of that is that the courts would be marginal players in the voice model. The key players are non-judicial institutions, the voice body, the executive government, and Parliament. The court's role is a minor and uncontroversial one of simply ensuring the voice model works as is intended. That is, the courts are there, if needed, to ensure the operation of the voice model conforms with the terms of the proposed Section 129 of the Constitution. So, furthermore, in contrast to a court-centred Bill of Rights model, in the voice model, ultimate decisions over laws remain with Parliament and the polity's elected representatives. This ensures that questions of public policy remain in the domain of politics, where they belong. The voice can make its views clear to government and Parliament, but ultimate decisions over government policy are for the government, and ultimate decisions over what laws to pass are for Parliament. So what the voice would achieve then is to clear barriers to political participation for the Indigenous community so that Indigenous people had a better chance of being heard, and this would in turn at least reduce the risk that policies and laws relating to Indigenous people would be developed absent Indigenous input. So it follows that the voice model may enhance the democratic system by ensuring the participation of groups that have not always had a chance to be heard and opening up policy making and lawmaking to a greater range of perspectives. In turn, if passed, the precedent set by the voice model could precipitate a more general opening up of government and parliamentary processes to a wider set of viewpoints, in turn making law and policy more responsive to the needs of the community. So I think ultimately what follows from the foregoing is that the debate over the voice is not at base a debate over courts or litigation, but a debate over how we ought to organise our democratic politics, and that, I would suggest, is where the focus ought to be. Thanks.
Okay, we've miraculously concluded right on time. And so it's over to you for questions. I mean, what you've just heard a range of different perspectives on the way in which the voice might, the courts might or might not become relevant in the context of the voice. And we're happy to answer any questions. I'll take questions, first of all, from the audience here, while the audience online starts thinking about it. Can we just, Jayani is monitoring the online questions. Can I just remind the people online that you can vote up questions that you think are particularly useful. And if you have a question, please address it to all of us or to a particular member of the panel. So over to you.
While I plan to vote for the voice, my fear is that its role will be merely advisory. This term representation sounds like advisory to me. And I wonder if there's not the danger that the voice will operate as a paper tiger, really not have any teeth to it. So, yeah, I'm not a lawyer, but it sounds like a lot of legalistic jargon to me.
Well, I think you've sort of nailed the idea of representation pretty well, lawyer or not. Does any member of the panel want to comment on that?
Well, I suppose, as Liz suggested, it is possible that pursuant to administrative law principles, in certain administrative contexts, taking into account the statutory scheme that governs the particular decision maker, a representation from the voice could in principle be a mandatory relevant consideration, which would mean that, for example, the government would have to take it into account to act lawfully in developing a particular policy. As Liz also noted, of course, the legal effect of representations made by the voice can be affected by the implementing legislation passed by Parliament under subsection 3 of the section 129 that was up on the overhead. And I suppose one benefit of the legal effect of representations by the voice being capable of being affected by that legislation is that over time, as practices emerge, the court can alter or modulate what the potential legal effects of the representation are. So the representation can never bind the executive or parliament to a particular outcome, and that reconciles the role of the voice with the principal role of the government in developing policy and the role of parliament as the representative of the polity in passing laws, right? So it can never bind those institutions to a particular outcome. But in regard to the executive specifically, statute can affect or change what the legal effect of the representations are over time. So if you found over time that government was routinely ignoring representations made by the voice, you could, for example, beef up the potential legal effect of those representations, but what they can't do pursuant to Section 129 is bind the executive to any particular outcome, because the executive has the institutional responsibility within our framework of government for developing policy, just as Parliament has the institutional responsibility for passing statute. So I suggest you're going to accuse me of throwing back a lot of legalistic jargon at you.
I will do that too.
But it's difficult to avoid it when one's discussing these questions of law.
But can I just say, I mean, the questioner is actually right, potentially. And it really picks up a point that Taryn made when she said a lot of this will depend on how it works in practice. If the referendum passes, we can expect that the Parliament will enact the relevant legislation in 2024, and then the next phase will be putting it into practice. That's what's sometimes called the implementation phase, and it will be critical. The voice is going to have to work effectively, and the institutions are going to have to respond to it effectively. And there's nothing sort of magic about the voice in that regard. It's like any change of any significant dimensions in our system. And if we can sort of effectuate the implementation of the voice, then it will still be advisory, but it can still be effective. It was interesting, we had a member of Parliament here in our last session who was talking about how the House of Representatives works. And she says, look, every time a piece of legislation comes to us, we have a note saying whether it complies with Australia's human rights. She said the next time, if the voice gets up, I expect we'll get a note saying whether it complies with representations by the voice. And it's just a simple little change to parliamentary procedure to get you thinking about how the institutions might work together to produce outcomes that are welcome on both sides. Welcome on the sides of Indigenous Australians, but also welcome on the sides of the government wanting to do better with Indigenous policy. So I do think the question is a very good one because it raises all of these important consequential problems.
I've got a comment and a question from Yusuf Salomon. First, a concern that courts are not elected, and the question is, how will the courts be bound by the voice?
How will the courts be bound by the voice? Yes. Okay, Liz, do you...
Well, the courts won't be bound by the voice. There's nothing in the amendment that directs any of the representations by the voice to any court. So I don't even think that the voice could make representations to courts if they wanted to. Good question if that's... But certainly they couldn't bind a court. I can't see... So I don't think that they will directly talk to courts, really.
No, but the courts will sort of look at the Constitution just like any other...
Yeah, just like any other...
Any other part of the Constitution. The court is bound by the Constitution itself.
I wonder what the panel, can you hear me?
Yes.
Thinks of the Frank Brennan suggestion. I think Ministers of the Crown is what he proposes be substituted for effective government.
Yeah. Look, are you happy if I answer that? Yes, Frank Brennan's did appear before the Parliamentary Committee, and his proposal was discussed in the report, including in the dissent, but not at great length. As I understand it, Frank, we don't have it up there and we don't need it back, but you remember that it's representations to executive government. Father Brennan would take out executive government and substitute ministers of state. Now, I don't think that's got anything to do with the judicial interpretation of the section. I think that's more to do with the idea that, well, the executive branch of government's a very big and sprawling branch of government, lots of people are in it, various different agencies. And if the voice is peppering representations right across the executive, could that be chaotic? And therefore, let's just identify the ministers as the people to whom that would go. Now, I think there's a number of reasons why that's not a particular problem. And Anne Toomey, Professor Anne Toomey, who appeared before the Parliamentary Committee, gave one. She said, look, I think what will happen is the Parliament will pass legislation under subsection 3 talking about how the representations will work in government. And just with any other advisory body, it will say, well, the representations will go in the first instance to X, and then X will distribute them out to various people. So that if the concern is that people are just going to be inundated with representations sort of dropping on all different parts of the executive, the argument, which I think is a good one, is that they can be channelled. And that in fact it's desirable that they be channelled, because if the Voice makes representations, you want them to be published. You want them to be collated. You want them to be available more generally to pick up the accountability of politicians to the Australian electorate, etc. So I think that's one answer. Another answer that I've seen to that concern is, well, Section 129 refers to the Voice making representations to executive government. The executive government might have a lot of things in it, but at the end of the day, it's a collective entity with cabinet at the top. And so again, the Voice representations can be controlled in that way. So I think that's the response to Father Brennan. And I think I'm right in articulating the reasons that he put the suggestion in the first place. Yes.
Yeah. I was just wondering if, we've had the native title process, and one of the outcomes of the native title process is prescribed body corporates are appointed, and these are recognised bodies by the government. Could those prescribed body corporates actually be the advisory direct voice to Parliament? Rather than, I'm just concerned how the advisory actually gets chosen. And if native title body corporates have worked so hard for years and years and years to get their native title, and they work together as an organisation, they should be the voice to Parliament.
Well, that assumes that you want a sort of disaggregated voice to Parliament all around the country. I mean, sometimes, of course, you will. I mean, take the Hindmarsh Island matter, where the issue was focused on a particular part of the country, although it's not necessarily the native title bodies that would have been helpful there. But I'm assuming that if there were a voice, the voice would relate to the local Indigenous communities who knew in particular about that matter. But if it's a different sort of problem, I mean, one of the issues that I understand is on the government's agenda is redrafting the Aboriginal and Torres Strait Islander Heritage Protection Act. Now, that's an all of Indigenous people issue. You want the ideas of Indigenous people from right across the country to feed into a review of that piece of national legislation. And it's not going to be satisfactory to get bits and pieces from different parts of the country. You need really someone to consolidate and funnel those views. But you're absolutely right that how the voice works at the subnational level is going to be a very critical issue for the legislation that's written in 2024. And I'm sure if the referendum's passed, and I'm sure that the bodies corporate to which you refer will be right in there trying to influence the form of that legislation. And a good thing too.
I think following from the conversation that you just had, Cheryl, I have a question from Eugene Teo. Could or should the voice be able to make representations to state governments and parliaments, seeing that most practical service delivery takes place at the state levels?
Yeah, it's an interesting question. I don't know, Taryn, have you thought about that? What do we think should happen at the state government level with the voice? Or do we think that the state treaty processes are going to fill that gap?
Well, it would be a shame for the national voice to take away all of the great work that has happened in Victoria. So I think that states should be left to determine how they want to have those relationships with their communities in the states?
Yeah, I think it's an interesting question, isn't it? Because we'll have some states that are going to have their own processes. Victoria's one, South Australia's another. Queensland's got legislation in the Parliament at the moment. Apparently New South Wales is moving down this path. So it may well be that you don't have replicas of the voice at the state and territory level, but that you do have something that operates as a similar sort of channel of communication between the Indigenous people of the state, in the state, and the state government. And I suspect that might be more effective if what we're talking about is state powers and responsibilities. So it's a question of how our federal system interacts with these processes. And I think it's quite interesting to see the experimentation going on at the state and territory level with all of this. I mean, I think the Victorian truth-telling process, I don't know what you think about this, Taryn, but it's really showing the way for others, the pitfalls and how you set it up and so on.
Absolutely.
You think? Yeah.
Been
watching it with some interest.
Thank you very much for the discussion tonight. Just on a practical level, would the voice, for example, be able to make representations to the Parliament through the Federation Chamber?
The Federation Chamber being the
Federation Chamber to the Australian Parliament.
The Federation Chamber, though, let me just be sure we're talking about the same thing. Is that the body that passes legislation quickly?
Yes, that's right.
So for everyone in the room, the Parliament has put in place a process whereby when there's uncontroversial legislation going through, it can be shuffled off to this thing called the Federation Chamber, where it will be passed very quickly without leaving the more controversial issues to be sorted out by the House and the Senate using their normal processes. So, I mean, I haven't heard anybody ask that question, but it's a good question, and I'm assuming that the answer to that is yes. I'm also assuming, however, that if there is, a question about legislation affecting Indigenous people, and if the Voice has decided that this is something that it's worth spending its time on to give a representation, that's probably something that shouldn't be dealt with in the Federation Chamber, but should be taken right back to the main debating chamber where the rest of us can watch what's going on and can read the transcript and so on. But thanks for raising the point. I think it certainly deserves consideration.
One ambiguous expression in the amendment is what is a matter relating to Aboriginal and Torres Strait Islanders. Are you of the impression that legal issue will not arise because it is unlikely that the implication will be drawn from the amendment that you've been talking about, whether it's necessary to take into consideration the representation in order to make a representation? So you don't think that legal issue would arise, is that right?
Well, Liz, do you want to...
Yeah, I think it could arise in the reverse. So someone would try to prevent the Voice from making a representation about something where it says it doesn't meet the threshold for some reason, and then someone might try to enjoin the Voice from making a representation on the basis that it doesn't meet the nexus requirement. Once in a blue moon, someone might try that, but it wouldn't. The words in relation to are words of broad connection, so it would be, I would have thought, a pretty low bar that the Voice can speak to a matter. So most of the time, if the Voice perceives it to be an issue of interest to it, I would have thought it will clear that hurdle. But it's not as though, I'm not sure what the concern is about that. The litigation risk coming from it only goes to the Voice, not to anyone else receiving the representation.
Yeah. So there may be two questions, and I may have confused one aspect of this. No. So there is the question of what those words mean. So that is it possible that the Voice could exceed its authority under subsection 2? Yeah. And that's the issue that Liz is just dealing with. I think there's a quite interesting question about whether anyone would have standing in the way that she talked about, and whether anybody is willing to spend the money on dealing with trying to sort out the meaning of words that at the end of the day are only going to produce a representation. So some of the hurdles that Liz talked about would come into play. But I agree that if those hurdles could be jumped, at the end of the day, you might get some court, which would not necessarily be the High Court, deciding or handing down some sort of decision about what those words actually mean. Now, if it managed to get to a court, I don't think a court would have particular difficulty with that, because our courts are very used to working out whether there's a connection, sufficient connection, between, in this case, the object of the law and the representation. But I used that example as well, and this may be where you're going, to say that I think the breadth of those words, matters relating to Aboriginal and Torres Strait Islanders, is one reason, one of a number of reasons, to do with the structure of the section, why implications are unlikely to be made. And that is because I don't think you necessarily know when you take a step as a parliament or even as a government whether a matter is one relating to Aboriginal and Torres Strait Islander peoples. You might come up with a rule about charging for prescriptions in pharmacies. and you do a general thing, it doesn't occur to you, it's got a special impact on Aboriginal and Torres Strait Islander peoples, but maybe it does. Maybe it's because the pharmacies in Arnhem Land are really teetering. And so you don't know that it's a matter relating to Aboriginal and Torres Strait Islander peoples. So how could there possibly be an implication that you've got to give notice that you're going to do it when you don't know that that's going to have that sort of impact? That's the only idea I was really playing with there.
It's also highly likely that the voice, it's got limited capacities, it's got limited resources, is going to seek to focus attention on particular policy areas of particular significance to Indigenous people. So there'd be very little incentive to move outside into something completely detached from effects on Indigenous people. And so that's a sort of a control in itself, right, that it will focus on particular policy areas.
Yeah, but in my example of the pharmacies, so the voice hasn't done it in advance either. The government hasn't anticipated. It's got a particular relevance to Aboriginal and Torres Strait Islander peoples. And then it happens. And the pharmacies in Arnhem Land are really struggling. And then the voice makes a representation. And one assumes that the government will be actually quite appreciative of that and at least acknowledges the fact. So you can just see how the give and take might actually play out in practice.
My question is kind of generic and not focused on a particular text of the article that we're discussing here, and also it comes from a place of initial ignorance to now some knowledge about what's happening out here in relation to Indigenous rights, etc. So a couple of things. Firstly, the whole connotation of calling someone Indigenous vis-a-vis the larger population, and I do understand, the role of the majoritarian rule, etc., in a constitutional democracy, etc. But if you just call them Australians, and the whole connotation of calling other people non-Indigenous, because somewhere terminology matters, things such as these, and then every time the mandate of in a public gathering acknowledging traditional rights, but does that have teeth? Has that done what it was meant to in the first place? Or having that kind of an acknowledgement even in official emails as part of people's signatures, are these only symbolic? And recently, I mean, just now I learned about the Federation Chambers. So and then going back to, I feel the quite apposite description of racism we just learnt about by Toni Morrison. So if something is already theirs, then shouldn't something like The Voice really go through a quick process and really non-controversial? So the larger theme of my sort of dilemma in my head is that why is this happening in the 21st century? If there is commitment, if Australia has commitment to the rule of law, and I am a lawyer, but certainly not a constitutional lawyer, is this, all of it is symbolic? Can we not expedite it?
Well, the interesting thing is that it's, I mean, when this all began, in its most recent phase, there was a desire to make it not just symbolic, and that's really the reason for The Voice, for it not to be just purely symbolic, but for it to be functional. So one of the reasons why I quite like putting the section up in the way that we did there is you can see it's got a symbolic element. You know, the opening part of it is quite nicely done. But then you get down to tin tacks with an institution, only an advisory institution, but nevertheless an institution, playing the sort of role that Jason described. So it's an interesting attempt, and I think it's a very Australian attempt. Now, at the moment, to go back to your point about why now, there is a debate on these matters going on everywhere in the world. New Zealand, Canada, United States. Just before I came in here today, I read that Greenland is about to try and separate from Denmark for very similar sorts of reasons. It's part of the logic, I think, of really finally rethinking what decolonisation actually means and believing in self-determination for people in a very complicated world. But this particular response, with its institutional focus, is a pretty Australian sort of thing to be doing. And if The Voice passes, it will be very interesting to see in comparative terms how it stands up and how effective it is in comparative terms by global standards. So we'll see.
Who would have standing to challenge The Voice having a voice?
I think that's the point. I don't think you could have standing at that broad level. It would have to be in respect of a specific decision or enactment, and that's different for every enactment, the standing obligation or decision that you're trying to challenge, I should say. So no one, I don't think, would have standing to challenge everything The Voice does that I can think of, but I think that you'd have to look at standing in respect of each decision that you're trying to challenge.
As a proud Porridor Army man and Aboriginal lawyer, I just want to thank the whole panel for this. I love, the detail of going into this and answering some of these issues that are raised about The Voice. But as mentioned, we sort of see this as part of the misinformation campaign that's out there as part of, the No campaign. And when we're dealing with friends and family that are lay people and trying to answer their concerns, they don't want to know all of this detail. So I was hoping maybe you could get just like a quick summary or thought of how to maybe just express just that little bit of why this isn't the issue that it is brought up to be when they talk about it clogging up the courts, just so something we can take away. Because I know sometimes when I'm talking to them, I get caught up in that legal side, and hoping maybe the experts can help me deliver that to them.
Yeah, well, fair enough. That's a really good suggestion. We do have a very basic fact sheet that doesn't specifically hone in on this courts thing. But it is online, and you'd be very welcome to use that. I've used it with some schools and things, and it's gone down quite well. But Genevieve, we're also doing some sort of shorter little things. So I'm looking at our comms people saying maybe we should take that up. So thank you. So look, the witching hour's just about here. So I think we should bring these proceedings to a close. Many thanks from me and Jason and Tim to both Liz and Taryn for participating tonight. You're both such busy people, and we very much appreciate all the care and thought you put into your splendid presentations this evening. And special thanks to you, Taryn, because we realise that many First Nations people are under extraordinary pressure at the moment, pressure both to come and do stuff like this, as well as being subject to an increasingly sort of wild debate. And so we really appreciate your willingness to rise to Tim's prompting and to be here tonight. Many thanks also to all those behind the scenes who helped us put this conversation together. As always, thanks to Angela Hendley-Boys and Avril Gaylor from the Law School. Thanks also to the University Communications team, and in particular to Genevieve Costigan, who's been a real partner in putting these series together, and it's been great working with her. And thanks to you, the audience, for attending here in person and for being online and for your thoughtful questions, and thanks to Jayani for fielding those. Just a quick word before you go about the future. The debate on the voice is about to enter into a new phase. The Constitution Alteration Bill presumably will pass the Parliament soon. It has passed the House of Representatives and it's now in the Senate. And once that occurs, the referendum campaign will begin with all that implies for public debate, both good and bad. So we're presently giving serious thought to how we can best use our knowledge to assist public understanding during this coming phase, and for that matter beyond, as we absorb the results of the referendum. So please watch this space and stay engaged with us. We do have a range of ideas about what we might do next, but if you have some too, we'd be delighted to hear from you about what they might be. So thanks a lot, everybody. See you soon.